Welcome to In the Name of the Law, with your host, Lisa Speaker from Speaker Law Firm. Joining her today is Stephen Sinas from Sinas Dramis Law Firm, Brandy Thompson from the Kronzek firm, and Mary Chartier from Chartier Nyamfukudza PLC. Now, let's discuss some remarkable stories and real cases.
Welcome back to In the Name of Law, a legal talk show about real people and real legal problems. Today we're covering police protest, insurance fraud, and what is an abuse and neglect case. Stay tuned.
In the name of personal injury law.
We often hear about insurance fraud, especially in auto accident cases. Today I have with me Steve Sinas of the Sinas Dramis Law Firm, and he's going to tell us more about insurance fraud. Hi, Steve.
Hi, thanks for having me.
So we hear about insurance fraud. Can you tell our viewers more about insurance fraud and how it's handled in our legal system?
Yeah, there are two essential types of insurance fraud, especially when it comes to auto insurance policies. The first type has to do with fraud or misrepresentations made by consumers when buying insurance. The second type has to do with fraud or misrepresentations made by people when they're claiming benefits under an insurance policy. So the law has these two separate areas and different rules and standards apply.
So can you give us an example maybe from your practice of where somebody might be accused of insurance fraud?
Well, let's talk first about fraud in the insurance buying process and how that can work under the law. So when you buy insurance, you're asked a number of questions. And with auto insurance, you're asked questions about who lives in your house, where your cars are garaged, how you're going to be using your vehicles. And when answering those questions, if you are at all untruthful or misrepresent anything, the insurance company can later then accuse you of committing fraud when buying that policy. And when you go to claim benefits under that policy, they at that point in time can go back to what you told them and say that, well, you told us something that wasn't the truth, so the policy that we sold you is void and we don't have to pay you anything. And I have had people come into my office for representation and they think they have benefits under their policy, but lo and behold, the insurance company can show that they answered one question untruthfully, and the law does give the insurance companies the power to cancel that policy altogether.
So just to clarify, they don't realize that their policy is no good, that it's going to be voided until they've been injured in an auto accident. Is that correct?
Right. That is right. And that's one thing I want the viewers to really understand. You can get through the insurance buying process thinking that you've snuck something by them, or if you didn't tell a complete story, think, well, it's not a big deal. They sold me the policy anyway. And then a year later, when you really need the policy, they then go back and unearth everything that you told them and then say, well, we don't have to pay you anything. Thank you very much.
So let's switch gears for a minute. You mentioned that there could be fraud in the claiming of benefits. Tell us about how that works.
Right. So if you have a valid insurance policy and then you seek to claim benefits under that policy, say in the auto no-fault insurance realm, where those benefits are very important for people who are seriously injured. They cover medical expenses, lost wages, household services. So you want to be able to access those benefits. And then you start submitting information to the insurance company and say that there's some piece of information that you submit that has something falsely stated, some misrepresentation, whatever it may be. The insurance company can then say, well, you just submitted a claim based on a misrepresentation or false information, and now we don't have to pay that claim, and we can subject you to other penalties as well. And the viewers need to understand those.
And what are those other penalties, Steve?
Well, in summarizing this, I want to first say that under the no-fault law, for the whole time the law has been in existence, there has been the right for an insurance company to not pay the fraudulently submitted claim and pursue attorney fees that they incur in trying to defend that claim. In other words, they're able to be made whole. They don't have to pay the claim, and they're able to claim their expenses from the person who fraudulently submitted the claim. But here's what I want the viewers to understand. Over the past several years, due to a string of appellate court decisions, appellate courts are the Court of Appeals and the Supreme Court, those decisions are allowing insurance companies to impose a much stiffer penalty for no-fault claimants. If the insurance company has a policy provision in the policy they sold you saying that they can void the coverage altogether if you submit a fraudulent claim or a claim that has any misrepresentation in it, if it has that, the courts are saying, well, if that event occurs, the insurance company can void the coverage altogether. So out of one misrepresentation for lifetime medical, a person can not only lose out on that claim, obviously, but then lose their coverage entirely. And this is having devastating effects on people who don't really maybe intend to submit a claim fraudulently, but somehow something's misrepresented. And now the insurance companies have all the incentive in the world to say, well, it was fraud, and now we don't have to pay that claim or anything else to you for the rest of your life.
So that brings up a question. Like if somebody just makes a mistake, is they're also at risk of having their insurance go away?
Well, this is where things are such in a precarious position for consumers. When a consumer submits a claim, they obviously should do so truthfully, right? They shouldn't submit anything that they know to be false. But there's a lot of information they submit, and things can arise where they didn't reconcile some, piece of information with another. As an example, I had a client who was submitting work loss benefits, and he was doing so for a number of weeks. And there was a week that came up where his factory shut down for a half a day, and he shouldn't have included in his claim that half day in his submission. He forgot to amend it to cover that day. It was kind of like a form document. And the insurance company later accused him of fraud. They didn't just say, we're not going to pay you that half day. They said, we're not going to pay that half day, and we're going to enforce the fraud exclusion against you and take away your coverage for everything you're claiming under the policy. And so the insurance companies, because they have this power, this very severe penalty they can impose on people, they're emboldened to make these arguments whenever they can.
And you said the appellate court's decisions are helping the insurance companies make these arguments. Is that right?
Yeah, and let me explain this a little bit further. In your insurance policy, your insurance company likely has now inserted a fraud exclusion that says what I summarized, that if you commit any type of misrepresentation in making a claim, they can void the coverage altogether. A number of Court of Appeals decisions have upheld those exclusions and have determined that people who submitted anything that has any type of false information, their coverage is void. The Supreme Court recently issued a very significant decision in the case of Mimic versus Fortson. And they said these exclusions can't be applied to people who weren't actual parties to the policy, people who were claiming benefits, say children, other people who weren't actual parties to the policy. These fraud exclusion provisions can't apply to them. But they left open the question of whether it can still be applied against the policyholder. So what I said about insurance companies still having this incentive, they do until the Supreme Court gives us clarity on this issue. And they left that issue open for another case.
Okay, so what about the no-fault insurance reforms of 2019? Did these do anything to address the issue of insurance fraud?
They did, and here's what they did. They allowed for the implementation and creation of a anti-fraud unit within the Michigan Attorney General's office. It's a criminal prosecution department. They're funded now with money to investigate insurance fraud, and when they find it, they are able to then prosecute people criminally for insurance fraud. And I just want to make it clear, insurance fraud is something that nobody should obviously commit. And if you do so knowingly, I believe there should be criminal penalties imposed against you. And those penalties already existed. But this anti-fraud unit now has more money to investigate. And perhaps that's appropriate. But what the reforms did not do is strengthen the rights of consumers against the bad faith conduct of insurance companies. We actually don't have very meaningful laws here for consumers to hold insurance companies liable for mistreating people. We have something called the Uniform Trade Practices Act, but the Michigan courts have held that doesn't allow people to sue the insurance company when the insurance companies commit misconduct or other type of prohibited acts. So consumers didn't get anything under the 2019 reforms. The insurance companies just got more power to hold people criminally liable for their bad acts.
Well, this has been very informative, Steve, and obviously everybody should be very careful when they're buying their insurance and when they're submitting their claims. But I would think that, if they are submitting a claim, they really need to work with an attorney to make sure they're doing it properly and
Right.
to avoid having an insurance company come down on them, maybe for an honest mistake.
Always tell the truth, obviously, but sometimes it's easier said than done. And the insurance companies, under these legal principles I've talked about today, they're emboldened to say that you've committed fraud, maybe even when you haven't.
Right. Well, thank you, Steve. Glad to have you on again.
Thank you.
In the Name of Personal Injury Law is brought to you by the Sinas Dramis Law Firm. In the name of criminal defense.
We can't ignore the protests that have been going on around the country, and people have very strong feelings about the protests themselves and what the people are protesting. Mary and Takura, we've seen people really resonating with the death of George Floyd. Why do you think that is?
People are protesting, like you said, because of systemic racism which exists in the criminal prosecution system. What George Floyd showed us is that if you're even fortunate enough to survive the police contact, if you're alive long enough to go home or even make it to the jail, right? We are charged differently with more felonies. And once we get to the point where a judge is sentencing us, we serve longer terms. And they are more onerous, the terms and conditions that we receive. So it starts right from the very first police contact. Even when you call for help, you may not even survive the police contact. And again, the numbers speak for themselves. We've had studies done in Washtenaw County and all over the country to show that it's not unique to any particular zip code. So this systemic racism, it exists now and has for centuries, I think, from the inception of the nation.
So there's been some violence and protests around the country. Are those the only protesters who are being arrested?
No, far from it. And actually, of all the demonstrations that we've had, I think almost 10,600 between the 24th of May and 27th of August. 10,100 of these, or nearly 95%, involve peaceful protesters. Fewer than 570, or approximately 5%, involve demonstrators engaging in violence. So a majority of these, about 80%, are connected to the Black Lives Matter movement or the COVID-19 pandemic. But everybody, the police come in, they're armed like soldiers. They come in barricaded and they just antagonize people, flashbang grenades and everything else, and they just sweep everybody. If you just happen to be in the area, la-di-da-di, everybody, we're taking you all in. So, no.
So is what's going on now consistent with arrests in the past for people who are protesting?
So we've represented a lot of protesters over the years, and we've represented a lot of people who were peacefully protesting and were still arrested. People who protested peacefully at government meetings, people who protested peacefully police misconduct, and they were still arrested and charged. We had people protest fracking, all kinds of things. One woman was videotaping an interaction between the police and a young Black man because she was concerned about what she was seeing. She was actually arrested for resisting and obstructing a police investigation when she was silently recording the interaction with her phone, and she was standing a significant distance away. So arresting peaceful protesters has been going on, as Takura said, since the inception of this country, continuing on now. People who are arrested are exercising their First Amendment rights. Majority of them are nonviolent individuals, and I certainly hope they litigate their arrest to the fullest.
And of course, we see the ones on TV are the ones where the violence is ensuing, which is the small fraction of them, like you said. So did the protests today seem different than what we've experienced in our nation's history?
So, this country was founded on protests, right? The Boston Tea Party, I'm originally from New England. Takura knows I love New England history. That was a protest by individuals against the government and, against England. So this country has a long, rich history of protest, and we start with the Boston Tea Party, and then we see it go on. We see the civil rights movement. We see the Stonewall, what are classified as riots. Those were predominantly gay men and lesbian women who had just had enough of being discriminated against and beaten and harassed, and they protested and protested and protested, and ultimately that led to the change of gay marriage. And it took 55 years, but that was the start of really that movement. And you saw that with the Vietnam War. Again, civil rights. listen, it wasn't just sit-ins and it wasn't just refusing to move from the back of the bus. I mean, it's a combination of civil disobedience and some of the property destruction that you see now. And I'm not advocating property destruction, but when you look at during the civil rights era, you're actually protesting lynchings, right? Black people are being lynched with, there's no due process afforded. If somebody didn't like you, they thought you committed a crime, you're being hung from a tree, right? So when I hear people upset about broken windows and again, I understand that. Nobody wants to see that. Nobody wants to see windows broken. But I mean, you have to step back and look at the broader context of people are losing their lives and individuals are afraid of the police. And that's not good. It's not good for society. It's not good for the police. And it comes from a real true place of a history of mistreatment. And we've got to look at that, and we've got to look at property destruction in the broader context of what is the concern here. Concern is loss of life. I mean, to hear people complain about a broken window when George Floyd is dead, it just boggles my mind. I mean, George Floyd cried out for help, and people. I mean, they're rising to that challenge. They can't help Mr. Floyd, but they can help prevent future Mr. Floyds by continuing to protest and continuing to let society know we've got to make a change.
So, Takura, earlier you mentioned systemic racism. Have you experienced, either as an attorney or just an individual person, racism?
Multiple times. So actually, Lisa, you have participated in the paper chase, right? A fundraising event.
Yes.
I was one of the people who helped plan it. So we got a permit from the Meridian Township Police Department. Along the route, I'm marking it. I've got chalk, I'm walking, and I had somebody, a police officer who fortunately I knew, and I dealt with on a case. He said, "Oh, I'm sorry. I know that you're probably doing this for the paper chase, but somebody called us, and I just have to respond." Even when I set off the alarm at our office, I had to show my ID, had to show the business card, and say, "Look, that's my name. That long name, the long one of the two with all the letters, that's me." Multiple times, too many to. Yes.
And who hasn't had to show an ID? Me. So when I set the alarm off, all I have to do is be like, "Oh, that's me. I'm the Chartier and Nyamfukudza." And they're like, "All right, ma'am, you know what I mean? Have a nice day." I mean, it is
anybody.
Right, exactly. I couldn't be, I could be just saying I'm the Chartier and, making that up. So it's vastly different how we're treated, very much so.
Do you see systemic racism in the criminal justice system?
We need to do an entire show on that. I mean, that we could talk about, you need 24 hours. You need far more than one segment. As Takura said, from literally the first time our clients interact with a government official until they're released from probation or parole. It is entirely built into the system. And I hope people watch the great documentary called 13th on Netflix. I hope people watch that. You absolutely see how systemic the racism is within our entire system. We see that every day, unfortunately.
Well, thank you, Mary and Takura. We're happy to have this really important conversation.
Thanks, Lisa. And for anyone interested in this topic and more, check out our podcast, Constitutional Defenders. We're on every platform where podcasts are hosted. Thanks, Lisa.
Okay, bye-bye.
In the Name of Criminal Defense is brought to you by Chartier Nyamfukudza PLC. Go to WLAJ.com for more information on today's topics and to view other In the Name of the Law episodes. In the Name of Family Law.
Welcome back, Brandy Thompson. Brandy is a partner at the Kronzek law firm in Lansing, and she does CPS defense and family law. Today we're going to talk about the whole range of what is child abuse and neglect. So to get us started, Brandy, can you just give us an idea of what child abuse and neglect is?
Sure, Lisa. And it may sound a little cliche, but I often say that what constitutes child abuse and neglect in Michigan is clear as mud. There are some laws out there, but for the vast majority of families that are falling under the purview of CPS for abuse and neglect investigations, it's not quite so clear. There are a various number of types of abuse and neglect. There's physical abuse, which comes to mind for a lot of us when we talk about CPS being involved, where there's an injury to a child due to some type of non-accidental incident. There's emotional abuse of children, medical neglect, where perhaps maybe a parent isn't or hasn't followed up with some type of medical treatment that perhaps doctors deem necessary. Educational neglect, where a child's education hasn't been attended to, a child misses a significant amount of school days and is not keeping up at their grade level. And certainly, finally, we also have failure to protect. And that is where maybe a parent or guardian wasn't directly involved, but they failed to protect the child from one of the other abuses from another person, perhaps another parent, a boyfriend, girlfriend that is in the home, and the responsible parent failed to protect the child from some direct incident that the other person caused.
So I've heard spanking is not illegal in Michigan, but yet I keep on hearing of cases that involve CPS that are coming into the system because of an allegation of spanking. Can you explain what is and what is not allowed?
Sure, yes. So spanking isn't illegal. That's absolutely accurate. However, there are limitations on that. When spanking rises to the level where it's causing the child a visible injury, such as a bruise, a red mark, something like that, often occurs where there's spanking on bare skin, and certainly any type of hitting above, where we're talking about the facial area, the ears, that type of thing, certainly would rise to the level where we're beyond we're causing injury or we are causing injury to the child. So leaving marks, that's certainly illegal. Another portion or another part of that is using objects. Frequently people who are spanking their child might use an object to do that, and that might be some type of, like a cooking spoon or a belt or a switch. That again surpasses that level of legal spanking into more the illegal range. And then we also have to look at sometimes the spanking in and of itself may not leave marks, may not leave a visible injury, but when we have repeated spankings or lengthy spankings, then we might go into that aspect that we spoke about earlier of emotional abuse, where the child is being psychologically harmed by the daily threat of maybe a spanking or some other type of discipline, physical discipline like that. So again, you look at the variables beyond just that initial spanking.
So switching, I wanted to ask about the age in which a parent can leave their children home alone without causing CPS or having a neighbor calling CPS and getting in trouble with CPS.
So this is another area, again, that specifically really relates to that clear as mud. And a lot of people will Google this. They think they know a specific age, but Michigan does not have a specific age where you can say this child can be left home alone for a specific amount of time. It just doesn't exist. There are guidelines out there, there are recommendations out there, but there is no bright line law or rule that we can all follow in every situation to say your child can stay home alone. That being said, what the courts or what CPS does look at, if you've left your child home alone and someone has filed an allegation against you because of that, you can look at, and they will look at, the age and maturity level of your child. How old is your child? The older they get, 10, 11, 12, and their maturity level, meaning are they physically and mentally able to provide care for him or herself? Do they obey the rules and make good decisions when they're home alone? And does your child feel comfortable being home alone? Have you talked to them about who to call if there is a emergency? Do they know how to reach out to 911? Or perhaps they have a neighbor that they can go to if they are experiencing some type of problem. So CPS will look at all of those factors if an allegation has been made that a child has been left home alone inappropriately, and make that determination. But again, that's obviously dependent on each individual child, each individual circumstances, with regard to each case, and then they make a decision or determination of whether or not the parent acted appropriately or inappropriately.
Does it make a difference, for example, whether it's daytime hours versus nighttime hours?
Yes, again, like I indicated, the older they are and the more mature they are, you can look at whether or not evening, nighttime hours, and length of time might be added into that staying home alone. But probably the younger they are, for example, a 10-year-old, you probably would not be appropriate in leaving a 10-year-old home alone after the evening hours, 9, 10, 11, and into the early morning hours.
So really somebody couldn't like work the night shift and say, well, my kids are sleeping, I can go to work and leave my kids home alone at that point.
Yeah, I don't think that would be the best choice for a parent to make, especially when CPS is taking up a lot of these types of cases. And I usually tell people, if they contact me and are asking these types of questions, is to err on the side of caution. If you're not sure, then you're probably, best case is to have the child stay with the family friend, the neighbor, or have a babysitter in the home. If you aren't confident that your child is of sufficient age and maturity level to handle being home alone at the times you're asking about and for the length of time that you're asking about, you better err on the side of caution and have that backup of a family member, an adult, to be able to help care for the child.
So switching, and I've worked on cases where the husband and wife might be in fighting with each other physically, or a boyfriend-girlfriend situation. It doesn't involve the child at all, but CPS gets involved. So why is that?
Yes, this is one of those type of cases where emotional abuse comes involved. Frequently, when there is domestic violence in the home and it escalates to the point where police are called, and they appear and the child is in the home, frequently they will contact CPS. And that is whether the child was involved in the domestic violence or simply witnessed it, heard it through a bedroom door. CPS will get involved to determine whether or not the child has experienced any type of emotional trauma or neglect as a result of the domestic violence in the home. And certainly their concern is, if this happened at this time, how often has it happened? Is this something that's a frequent occurrence? And that will determine perhaps, whether or not they will continue their investigation into this family.
Well, thank you, Brandy. We have a lot more to talk about for the rest of the season, so this was a great start, giving us the basics about dealing with CPS. Appreciate your time today.
In the Name of Family Law is brought to you by the Kronzek firm.
Thank you for watching In the Name of the Law. We look forward to seeing you next week.
Thank you for joining us today for In the Name of the Law. Please go to WLAJ.com for more information on today's topics, and please join us next week for another informative show.